international network of interdisciplinary experts on water resources. It's a non-profit, non-governmental organisation established in 1971, and one of our key focuses is to link good science and good knowledge to policy. So this is the reason why we've started a series of webinars this year. The first one was launched during World Water Day in March this year, and this is our second one focused on the UN Watercourses Convention. All of these webinars and policy briefings are linked to special issues of our water resources journal called Water International. And last year, in March last year, IWRA published in partnership with the Dundee Centre for Water Law and Policy and with the World Wildlife Fund, published a special issue called the 1997 UN Watercourses Convention, What Relevance in the 21st Century. Now, seeing how the 35th states acceded to the convention just recently, and that the convention shall be entering into force very soon, this is the reason why we thought it timely to make this webinar on this subject. I would like to introduce you to my colleagues here before I pass over to the seminar itself. Firstly, I'd like to introduce Professor Alistair Rieu-Clarke. Perhaps, Ali, you can give a wave to our audience. He's from the University of Dundee, the Centre for Water Law, Policy and Science. We also have Miss Flavia Loures, who's an independent consultant and PhD candidate at Salman University. We have also Mr. Remy Kinna, who is Humanitarian Program Management Coordinator at Oxfam Australia. And all three were guest editors of the last special issue that we made on of Water International. We're also joined by Dr. Salman, who is a fellow member of the International Water Resources Association and former water law advisor to the World Bank. And we're also joined by Professor Owen McIntyre, who is senior lecturer at the University College Cork. Now, without further ado, I'd like to pass over to my colleague, Mr. Scott McKenzie, and I shall be signing off from the video screen, who is IWRA webinar coordinator and who shall be moderating today's webinar. Thank you very much, and I wish you all a very successful and fruitful webinar. Thank you.
Hi everyone, I'd like to welcome you to the webinar today. Thank you for tuning in. Just to give you a quick overview of how we're going to organize the session, we're going to give each of our panelists a few minutes, a brief 5 to 10 minutes for a presentation. Some of them will be utilizing PowerPoint, some you will just be able to sit back and enjoy listening to. And afterwards we will make those PowerPoints available on our website. And then after the presentations, we will shift to doing questions. Several of you have already sent in questions. Thank you. I have your questions already printed off, and we will have them at the top of the list. Everyone else, if you'd like to ask questions, there should be a box on your GoToWebinar control panel where you can type questions. You see it says questions. You can drop it down and type them in, and I will receive them here, and I will direct them to our panel when appropriate. Feel free to direct your questions to one panelist or to the whole group. Just let me know in the typing of your question what you'd like to do, and I'd be happy to do that for you. But we really like to turn a lot of time to questions and answers, so that you have the most interaction with the panel. I think without further ado, Professor Alistair Rieu-Clarke, you're on the top of the list, and we will proceed to you.
Hey, thanks, Scott. Also, thanks to Tom and the IWRA colleagues for organizing this webinar. I hope everyone can see my slides here. I'm talking about the authority of where the UN Watercourses Convention derives its authority, and so I'm not going to focus entirely on this why entry into force matters. I'm really sort of looking at that history, but that history is very important for then discussing these questions of the value of entry into force. So I think that will become obvious as our discussions come along. Well, it's a long history, the drafting and the negotiation and adoption of the Watercourses Convention. In 1959, it was a UN General Assembly resolution, so all states coming together to call on the Secretary General of the UN to conduct studies on the legal problems relating to the utilization and use of international rivers. And by doing that, asking member states to provide information regarding their laws and legislation, bilateral treaties, decisions of international tribunals, including arbitral awards, and surveys and studies of non-governmental organizations concerning international law. So working out what the existing practice was already out there. That work led to a decision, again by the UN General Assembly, in 1970 to ask the international law, the legal body of the UN expert body responsible for codifying customary international law. Customary international law is seen as unwritten law. So taking that unwritten law and codifying it, putting it on paper within a set of draft articles. Why did states within the General Assembly think that was an important thing to do? Well, the reasons they gave within the resolution in 1970 are I would say highly relevant today, around concerns around population growth, increasing and multiplying need, demands, a growing concern of humanity, fresh water availability being limited, need to protect and preserve water, seen as important to all nations, conscious of legal problems, disputes, etc., around transboundary waters, and quite an important point, I think the last one, despite a great number of treaties, bilateral, multilateral, basin-specific, regional treaties, the law was still based in part on general principles and rules of customary international law. So we need to add more clarity to the rules and principles of international water law. There's a key aspect of this exercise. And it was a very extensive exercise. I'm not going to go through all of these bullet points, but this is just to show you that there was a lot of work done by the International Law Commission to firstly understand this existing practice, how some common trends going through these different bilateral basin-specific treaties within different regions of the world. And that's why I titled this slide "Bottom-Up Approach," because this wasn't an exercise where independent experts within the International Law Commission came together and thought, well, from our viewpoint, what would be an ideal set of rules and principles for sharing international water courses. Rather, it was an exercise in trying to understand what existing treaty practice and other practice, decisions of courts and opinions of experts and so forth, what practice was already out there, and how could that be put into a nice concise set of rules and principles. And then it's also important to recognize that the states played a really strong role in the drafting of a convention. So the drafting exercise, through the work of the International Law Commission, which lasted from that request in 1970 to 1994, when they produced their 94 set of draft articles on the law of non-navigational uses of international watercourses. There were a number of opportunities there for states through questionnaires solicited by the International Law Commission, asking states for their opinion on the direction of that work. That fed into the development of those draft articles, and then the draft articles were presented to the UN General Assembly, and formed the basis by which states could then draft the Watercourses Convention. So they took a conscious decision to take those draft articles and negotiate within the 6th Committee of the UN General Assembly in 96 and 97, negotiate a convention on the law of the non-navigational uses of international watercourses. So that process went through. The draft articles were discussed. The ILC draft articles were discussed, article by article. A number of recorded votes were taken on more contentious issues around the texts, around our existing agreements in Article 3, the relationship between equitable and reasonable use and no significant harm, Articles 5 and 7, and dispute settlement, whether that should be compulsory in Article 33. And within within those discussions, which is freely available on the UN website, you can see 54 nations recorded statements on their view on what this convention should look like. What was the outcome of the negotiations? Well, the convention was adopted in 1997. A recorded vote was taken when the convention was adopted. 103 nations voted in favor, 3 subsequently informing the UN General Assembly that they intended to vote in favor, 27 abstentions, and 3 nations voted against: Burundi, China, and Turkey. And there were, again, on adoption, there were a number of statements for and against the convention by various states that I've listed there. So just in a final remark, I wanted to emphasize this persuasive power of the UN Watercourses Convention, and think that the international law generally has, we describe it as a horizontal system. There's no police power that oversees. It requires on reciprocity between states to ensure it's the rules and principles of international law are complied with. And so I think what that means is that it makes that the perception of the legitimacy of international law becomes really important, and then so these processes by which rules and principles are formulated, adopted, and implemented are crucial. And I think what we see with the Watercourses Convention is that it certainly does have this really long history, a deliberate exercise of engaging with states within the General Assembly and through the work of the International Law Commission. That really does give it quite a lot of persuasive power. And just one bit of evidence of that that I've put up here is a quote from the International Court of Justice, who when they were deciding the Gabčíkova-Načmoroš case between Hungary and Slovakia, mentioned the convention, and mentioned it in September 1997. So pretty soon after it had been adopted in May 1997, and they described it as providing evidence of customary international law even before it entered into force. And so I think this just attests to the importance and the persuasive power of the convention, and the more we can do to advance that persuasive power, perhaps by more states joining the convention, developing tools and mechanisms to enhance its implementation, to promote it and enhance its implementation, the better. And other presenters will go into a lot more detail on these aspects than me. So I'll leave it there, yeah, I hope that gives a nice overview at least of where this convention came from. Thank you.
Hello everyone, greetings from Brazil. So what I would like to do, make 4 main points here. I know usually they recommend that you stick to 3, but I can never follow the rules very well. So I'll go for 4 points. First of all, kind of touch upon again of what Alistair said, the role of international water law. So we're talking about the UN Watercourses Convention here, which brings international water law together into one document. So that brings us back to the question, why international water law is important to begin with. And so what international water law does and why the convention was adopted to facilitate sound water management in transboundary basins, ultimately leading to the achievement of larger conservation and development goals. And through history, experience, and my colleagues that have been working on this for far longer than I can attest to that than me, international law has been a central tenet of good cooperation. It has played a vital role. And it's actually among the most influential factors in how states behave in their relations pertaining to international waters. So if we reach this conclusion, then automatically we get to the point of thinking, well, if international law has this important role to play, what can we do to make it even stronger, to enhance that role so that it's definitely fulfilling its intended functions? So, and that leads me to the second point, the status of international water law. As Ali said, we still have a very fragmented state of things. If we look at most of transboundary basins in the world, most of these basins are not covered by specific agreements. Even where we do have agreements, a lot of them have gaps and weaknesses, as we could see, or they fail to cover the entire basins. They exclude groundwater, or they don't involve all the basin states, for example. And then we can talk about specific examples during the questions after that. Another problem that we have is that some basins are covered by too many agreements that are not necessarily aligned with each other. And a lot of states out there are parties to a set of different agreements, again, not aligned, and that has not facilitated, that has not made implementation easy. I think that's the case in Central Asia, for example, where you have, one may think, too many agreements, in fact, and sometimes pointing to different directions, sometimes overlapping, and just making implementation of those really, really hard. So in this scenario of too many agreements or not enough in some places, how do we ensure that international law is actually a tool to facilitate and not make things more difficult? And that's where we come up with the idea of the multi-level governance of transboundary waters, where you have different instruments at different levels that are mutually reinforcing and supplementing one another. And that's where the Watercourses Convention would come at the global level, supplementing agreements at the basin, sub-basin, or regional level, to codify, clarify, and contribute to the development of international law. And in sum, what is the Watercourses Convention? It is a clear, stable framework of cooperation at the global level. And so in this context of the multi-level governance of transboundary waters. Very quickly moving into the third point, and here Salman will discuss this in greater detail, but from my perspective, from the experience that I've had working on the ratification process at the World Wildlife Fund, and very closely with Ali and Owen here and Remy, entry into force is going to represent ultimately, both legally and politically, the milestone of when we talk of successful codification and development of the law. It's not that all the problems are solved here, but it is a milestone that all the efforts of the International Law Commission have come to fruition. It's a process, and entry into force represents this milestone. And then where we go from here, I'm going to touch on that in a second. So now parties, the states that ratify, will have a common legal basis that it's clear, that is broad enough to cover a number of situations, and that it's binding on all of them, and ultimately sediments the rules and the principles of international water law, and even more of that, more important, where the direction that these existing rules are evolving. And Owen will talk about ecosystem protection and how the convention does that. So where we are and where we are going, and eliminating any questions that the countries might have is equitable use an important principle. Once the convention enters into force and it's binding upon those parties, everything that it's in there, it's agreed upon by the states. You don't have to discuss anymore what's customary, what's not, what's developing, what's not. Everything is agreed upon. So it's an accepted basis for negotiation. I think that's very important. And very practical aspects here. So getting out, moving beyond the very legalistic world. One thing that we saw when we were working on ratification is in many places there was just not awareness, not knowledge of what the convention represented, and that made ratification itself very difficult. What entry into force does is raise the level of awareness of the convention, puts it under the spotlight even more, and we can see that countries are more curious about it and what it does and why it's important. So that kind of political power, entry into force, increases that to a significant extent. And what we hope will happen from a ratification perspective, of course, entry into force is one step. What we would like to see in 5 years, maybe hopefully sooner than that, is universal ratification like we have for the other environmental conventions. So, and what we think could happen with entry into force is a snowball effect. Now more and more countries will become interested, more and more will ratify, and we'll have eventually an even more powerful instrument that we can use. And so bringing these effects together, what we have is greater clarity of the law and an understanding of what the law represents among a larger set of countries. And the expectation or the assumption is that those two elements, greater clarity and a shared understanding, would lead to better levels of cooperation. And just to give you two quick examples here, and then I'll close. I'm no authority on the situation of the Nile Basin, but just what I follow in the media and through my colleagues, the last development was that Ethiopia and Egypt would agree on a process going forward to discuss the potential impacts of the Renaissance Dam. Were they parties to the Watercourses Convention, they wouldn't have to go through this one additional step. They would simply know from the other that whenever one wanted to develop the watercourse, they would have to follow the standards and the procedures of the Watercourses Convention. So instead of going through this one additional step, let's create a committee. And then they moved back from the committee. Negotiations were stalled for a few months, and now they are back at the table and they're going to agree on the steps to follow. So why go through all this? Why make cooperation so difficult when you have the steps set out in the Watercourses Convention? So an example of where the convention would have a very strong facilitating role to play. And then the other function that the convention plays is to support existing multilateral environmental agreements. So, for example, in the case of Ramsar, I think largely due to imminent entry into force, Ramsar is working on this paper now, looking at relations between the regime that Ramsar creates with the broader regime of international water law. And once the convention enters into force, the UNECE Water Convention becomes global, how Ramsar can help with implementation of the Water Convention and vice versa. So that awareness itself, entry into force, is creating and leading to the parties to the Ramsar Convention to think about these issues as well. So one legal example, one more practical example. Scott, how am I with time? Do I have time for one final point?
Yeah, if you could make it brief.
Brief, yeah.
Thank you.
I will. So upon entry into force, we have a very important and urgent window of opportunity here to prepare for entry into force. As we know, this is due to happen now in August. The convention will enter into force with Vietnam's ratification. So 3 things here to keep in mind, and hopefully we'll go back to these during questions. The convention is not isolated. It's going to be part of a broader context of an existing transboundary water management governance framework. There are a lot of actors out there already working on this issue. So the convention has to be seen within this context. And then the big question is, what can those organizations do to support the parties to the convention now that it's entering into force? And then we can think about the Global Environment Facility, river basin organizations. UNEP is having a forum in November this year that will, among other issues, discuss exactly that, bring the river basin organizations around the world together and say, the convention is now in force. What facilitating role can you play to your member states with regard to that? The other point, coordination with the UNECE Water Convention. This is also a global instrument now. Soon countries will be able to ratify. We'll have 2 global water conventions. How do we make the best out of this and without creating confusion on the other hand? And Remy will go in detail on this issue, but it's something important to keep in mind. And then the final point, through the experience of ratification, what we've learned is the absence of a established basis for the convention or an institutional home has made it very difficult, has made things much harder when it came to ratification, because there was no one champion, one authorized with authority to pull countries together to the ratification process. This is even more important when we think about interpretation, application, and implementation. So the convention does not have provisions on secretariat and meeting of the parties. We don't expect that those things will exist immediately upon entry into force. I think there's a lot more discussions to happen, weigh the benefits of, do we really need these instruments, and then the financial and political costs involved. But the key point that I wanted to leave the audience with is we need to have things better organized now than we did while we were at the ratification stage, including to motivate more countries to ratify. So how we create, however informal, how we create some sort of institutional home, building upon what's already out there, the Watercourses Convention Global Initiative that WWF worked on with Dundee, Salman, Owen, and IWRA. How do we build on this experience, the experience of the UNECE Water Convention, to make sure countries have the backing that they need, the funds, the support, to now start talking about implementation? And that's for the existing structure working on transboundary water management to advise on, and then for the countries that have ratified to make a decision. So with that, I thank you, Scott, again for that invitation, and looking forward to the other speakers.
Well, thank you very much. I think that was a very informative presentation, and I appreciate your perspective as almost someone who boots on the ground. It was a very learning from the work you've done. Thank you for that.
Hello, everybody, and thanks to Tom and Scott for organizing this, and to the other colleagues in IWRA. Ali and Flavia have really set the stage for my presentation by giving the historical and background and the international law background where the convention fits. I'll talk specifically about why does the UN Watercourses Convention enter into force does matter. Next, and I have 6 reasons. Next, Scott. 6 reasons why I would think that the entry into force of the convention does indeed matter. Those 6 reasons are not necessarily exclusive. I'm sure there will be other reasons which people can come out with, colleagues or in the panel or in the audience. And quickly, I'll mention them and we'll go into a little bit of more details on each of them. The first one is the end of uncertainty of the status of the convention. I think this is an important aspect. And the other thing is the end of characteristic of freshwater as a main shared natural resource without a treaty regulating its management and sharing. Third reason is the reconfirmation of the principle of equitable and reasonable utilization as the guiding principle of international water law. The fourth principle, or the fourth reason, is the convention as a reference treaty for judicial and arbitral tribunals. And I put IFI, meaning international financial institutions, because I think that probably qualifies as a separate and sixth reason. By international financial institutions, meaning the institutions that provide credits and loans for projects, obviously including projects on international waterways, and their need for guidance on how to deal with them. And the last and most important reason is that the convention really does represent codification of the main principles of international water law. And Ali and Flavia went in details about this issue. I would like to end up with the global endorsements of the convention. Next, Scott. So the first reason is the end of uncertainty regarding the status of convention. As mentioned by my 2 colleagues, it was almost half a century since the start of the process in 1970, and I don't want to go back to 1954 by the resolution that calls for studies on utilization of the rivers, but I'm going to go directly to the resolution that pointed to the convention, and that was 1970. That was a resolution which, as Ali mentioned, asked the International Law Commission to look into the issue of codifying the principles of customary international law into convention. The International Law Commission took 23 years and ended its work in April '94. And then we had 3 years of the convention hovering around in the General Assembly and the working group of the whole until May '97 when it was adopted. And then 17 more years for entry into force. A very long and turbulent journey. Very complex, very turbulent journey. So that has raised a lot of questions about the uncertainty of the convention. And I wrote an article 7 years back entitled the UN Watercourses Convention, Why Has Its Entry into Force Proven Difficult? And I got replies back saying, oh, it's not difficult. This convention will never enter into force. It's just too complex, and it will not enter into force. And I was in a conference 3 years ago where it was mentioned by a couple of speakers. It was a regional conference that this convention is not relevant, and the fact that it wasn't relevant appeared in its failure to enter into force. I think it would have been a major disappointment for all of us who are working in this area if this convention were to hover longer in that limbo stage, in that uncertainty stage. So I think this has finally ended. I think this is a major important point that why it matters, because it has entered into force and has ended the state of uncertainty. Next, Scott. The second reason that they had is the end of characteristic of water, shared water resources as the main natural resource, environment area without a treaty. If we look at the maritime waters, the law of the sea, it had a convention, it has difficulties for negotiating it, had difficulties of entering into force, but finally it did enter into force, and we have a treaty for the law of the sea. In the environment, we have the Ramsar Convention, which deals with water and land, and the environment, we have the environment generally, we have the Convention on Biological Diversity, we have the UN Framework Convention on Climate Change, and we have its protocol, the Kyoto Protocol. So shared water resources remain the area until Vietnam submitted the 35th instrument of ratification, remain the major area without a treaty regulating its use and management. And so that characteristic of freshwater as the only area, or as the only major area of a shared water resource, of a shared resource without a treaty, has ended. So we no longer have to really be concerned about the fact that this is not an area that doesn't have a convention or a treaty regulating its uses and management. Next. The third reason I had in my presentation on the relevance of the convention and why it's entered into force does indeed matter is the reconfirmation of the principle of equitable and reasonable utilization. And this is a complex issue. The large number of a large part of the 23 years were spent by the ILC dealing with the issue of whether equitable and reasonable utilization subordinates the no harm obligation or the vice versa, and that also was the main issue for the 3 years. The ICJ, the reading of the convention, and I have written about that, is that the convention does indeed subordinate the principle of equitable utilization, the no harm rule, the principle of equitable utilization, meaning it is a convention enshrining the principle of equitable and reasonable utilization. And that was endorsed by the ICJ in the Danube case. And in my view, the entry into force of the convention with all the endorsements of this approach would end the debate on which of the two principles subordinate others. The principle of equitable utilization is not, as generally understood, would favor the lower riparian, the upper riparian. No, it's for all riparians. It has elements which are used to decide the equitable utilization for each riparian state. So I think that debate, in my view, has been put to end by the entry into force of the convention. Next. That takes me to the fourth reason of the relevance of the convention and why it's entering into force matter is that there is now a treaty which is a reference for judicial and arbitral tribunals. We have a number of, the PCA had a number of cases, the Permanent Court of Arbitration, the ICJ had 2 cases. There are other cases that are likely to go somewhere, regionally or internationally. We had the Kishenganga, which was decided recently by the PCA, and before that. So I think now there is a reference treaty. In the past, you look around, you look at the Helsinki rules, you look here and there, you look at the decisions of the Permanent Court of International Justice. Now we have a reference treaty which the international and regional judicial arbitral tribunals would use and would look at. And this was clear when the Danube case was decided 4 months after the adoption of the convention by the General Assembly. And the General Assembly and the International Court of Justice referred to it extensively. It did refer again to it in the pulp mills case, Argentina versus Uruguay. And the interesting thing to notice is that when the International Court of Justice endorsed and referred to the convention, none of the 4 parties to the cases, Hungary, Slovakia, Argentina, and Uruguay, was a part of the convention. Nevertheless, the court went ahead and endorsed the convention. Of course, Hungary became a member later in 2000. So henceforth, the convention will be the main reference treaty for international and regional and judicial tribunals. Not only this, but it will also be a reference for international and regional financial institutions. During my years as the water law advisor for the World Bank, I would get calls from all over the world. Asian Development Bank, African Development Bank, DFID, the British Aid Agency, GTZ, whenever they have a project on international water course. What do you do, guys, in the World Bank? How do you handle it? What should we do to avoid problems with other riparians? And I think now there is a reference for those institutions. And I think, if Flavia may correct me, but one reason why the UK ratified the convention was, or seized the convention was, because they felt that they have something to use in their foreign aid, in their aid to the for projects on international waterways. And I think this will resolve the problem with many of the institutions that don't have a policy on how to handle projects on international waterways. Yes, of course, the World Bank had a policy, but still, and this will strengthen the policy of the World Bank, because we worked very, I said we because I was in the World Bank at that time, we worked very closely with the ILC, and we put in the table the experience of the World Bank on notification, which was used extensively by ILC, including the article on indirect procedures. So I would Scott, if you don't mind, I will later on make this as a separate reason, because I think it's important. Can we go to the next slide? And that takes me to the most important reason for the relevance and for the why it should matter, that the convention has indeed codified the principles of international customary law. And this will be clearer in the resolution referring the issue to the International Law Commission. It talks about codification of the principles. And those principles focus on international law, cooperation, equitable and reasonable utilization, obligation not to cause significant harm, protection of the watercourse environment, notification of planned measures, peaceful settlement of disputes, and negotiations in good faith. Those are the main principles of customary international law and the principles that have been codified and incorporated into the convention. So in that case, this is really, it's not coming with any new principles. What it has done, it has codified the principles of customary international law and put them in the treaty. Next, Scott. So it has put them in treaty, and that I think is a major achievement and a major reason for why we should be happier and about the entry into force of the convention, that it has codified customary international law. And this, as I said, mentioned earlier, the ICJ referred to the convention, though none of the parties of the 4 parties to the case were involved. And this, in my view, and I would like to listen to my colleagues and to the audience, is that the binding effect of the convention will go beyond the 35 state parties, because it is customary international law. It will go beyond the 35 parties. And so the fact that we only have 35 parties to the convention, in my view, does not at all matter. I think what matters is that the convention has entered into force and has codified those principles, and those principles will be binding on all the world member community, regardless whether they are parties or even they intend to be parties or not. And I think this is a major achievement and a major reason why the convention should indeed matter. Next, Scott. And the question of the convention having indeed mattered was clearly shown up in the endorsements. There were global endorsements for the convention from day one. The World Commission on Dams, that was established in 1998 and issued its report in 2000, had a major endorsement of the convention, asking the countries to sign, ratify, or accede to the convention. The World Water Council did the same thing and issued a very strong statement endorsing the convention. The World Commission on Water for the 21st century, that was established by the First World Water Forum and prepared for the Second Water Forum, had a very strong endorsement. And the International Law Association in 1996 is meeting in Helsinki, 1996, not 66, 1996, welcomed the fact that the ILC has finished the work and that the working group will look at the convention as a group of the working group of the whole, and it welcomed in very clear terms. And we look at the influence of the convention, or the persuasive power of the convention. The Southern African Development Community Protocol of 1995 was amended after the convention was adopted, basically to include the provisions of the convention. It became a mirror image of the convention. The Lake Victoria Protocol has been based largely on the convention. The Zambezi River Agreement. The Mekong River Rules on Notification are by and large a copy of the rules of notification of the convention, and the Nile Basin Cooperative Framework Agreement, which has not yet entered into force but has been signed by 6 states, was based largely on the convention, especially on the issues of equitable and reasonable utilization and the obligation not to cause harm, the environmental protection, and the main principles of cooperation. Next. So this leads me to the conclusion. I hope I have a minute for just to go quickly through my concluding points, which more or less reiteration of the points that I have mentioned, that the entry into force of the convention should indeed matter, fill the major vacuum in treaty law for one major shared natural resource. Second, codified customary international law. Third, provided the clear and unequivocal reference to international and judicial tribunals for resolution of international water disputes, and provided also a clear and unequivocal reference for international financial institutions, whether they have policies or not, on how to deal with projects on international waterways. And it will definitely influence other states to join, what Flavia called the snowball effect, also Stephen McAfee called the snowball effect. states will join now that the convention has entered into force. Thank you very much. The last slide is really thank you very much slide, and I will stop here. I hope I haven't exceeded my time in any manner. Thank you very much.
Thank you very much. I think that raised a lot of interesting points that many of us may have overlooked. It was a thorough discussion of the many reasons that we can look forward to the UN Watercourses Convention. Now, our next presenter is Dr. Owen McIntyre. Dr. McIntyre, just give me a second here. I'll get all set up. I'd like to remind our audience that we are still taking questions. If anyone would like to add a question in, we've had a few coming in already. It is on your control panel, your GoToWebinar control panel. You can see there's a box that says questions. If you merely type the question in, I will receive it and then can direct it to our panel at the conclusion of the presentations. We will try to get to all of them if we can, and if not, we will do our best. So without further ado, Professor McIntyre, the floor is yours.
Thank you, Scott. I hope everyone can hear me. I'm listening, or I'm joining from Xiamen in China, and I'm having some problems with the audio of the previous three speakers, so I hope that people can hear me. The three previous speakers have talked about the UN Convention as a codifying instrument. Alistair mentioned that it picked up on trends in the practice of states and in customary international law, that it picked up these trends, it compiled and ordered these trends into the form of a conventional or conventional rules. And I want to talk about one of those specific trends which the convention codified into a conventional rule, and that is the protection of watercourse ecosystems, or commonly referred to as well as taking an ecosystems approach to the protection of shared watercourses. This was not created, this idea was not created by the convention. It existed in practice before the convention, but the convention provided a quite emphatic endorsement of the principle. Article 20 talked about an obligation of states to protect and preserve watercourse ecosystems. The International Law Commission had described this obligation as a specific application of Article 5, the requirement for adequate protection of the watercourse. That, of course, suggests that equitable balancing is required in respect of that rule. It also talked of it as an essential basis for sustainable development, and said, importantly, that it had ample precedent in state practice, and I think we can demonstrate that that's quite true. Also, Article 6.1, which set down relevant factors for equitable and reasonable utilization, lists a number of factors which are inherently ecological. And of course, parts 4 of the Convention on Protection, Preservation and Management, where Article 20 is located, also included related obligations on management of environmental pollution, alien and invasive species, the protection of the marine environment, and also on sustainable management and the regulation of flows, all factors which are relevant to protection of ecosystems. But of the three global instruments, the UN Convention, the UNECE Helsinki Convention, the preceding convention from 1992, which is now a global instrument, and the International Law Commission's 2008 draft articles on transboundary ecosystems, they all include an element or a variety of, or a form of an ecosystems approach. The UNECE Convention, again, quite emphatic, talks about the need for conservation and restoration of ecosystems, requires states to promote an ecosystems approach, talks about the ecologically sound management and protection of rivers and lakes, international rivers and lakes. And of course, that convention gave rise, or other conventions adopted under its auspices or influenced by that convention, including the Danube Convention, Meuse and Scheldt agreements, the Rhine Convention, and even conventions that preceded from the European region, like the Elbe Convention, all include provisions which support protection of ecosystems. The draft articles, the ILC's draft articles, again, stresses the role of an aquifer in a related ecosystem. And Article 10, the equivalent of Article 20 under the UN Watercourses Convention, an obligation on states to protect and preserve dependent ecosystems dependent on aquifers. But there has been a trend, to go back to Alistair's point about the role of the Convention in compiling, picking up on, identifying, compiling and ordering these trends in the form of conventional rule. We see provision which promote the protection of international watercourse ecosystems going back to 1969. So a number of examples are provided there, I won't go through them in detail. We also see in declarative practice soft law instruments going back to 1977 at least, many instruments that support this trend. Notably, Chapter 18 of Agenda 21, remember, a soft law instrument signed up to by 180 states. It talks about preserving the hydrological, biological, and chemical functions of ecosystems. It talks about water as an integral part of the ecosystem, and promotes safeguarding the functioning of aquatic ecosystems. So again, emphatic support. We have judicial support for an ecosystems approach. We have implicit judicial support going back to the 1997 Gadjikovo-Najimaros case. In the context of precaution, it talks about the need for vigilance and prevention, principles of vigilance and prevention because of the irreversible character of damage to international watercourses. Again, that to my mind strongly suggests ecological damage. And it similarly talks about limitations regarding the reparation of such damage. The pulp mills case from 2010 emphasized the customary duty regarding EIA. Well, EIA, transboundary EIA or EIA of projects on rivers is an absolutely key means of implementing an ecosystems approach, requiring a proactive study of the possible implications, possible impacts of a project. But much more pointedly, the recent Kishinganga arbitration, the interim award from 2013 and the final award, place stress on an obligation to maintain environmental or ecological flows in a shared watercourse. And interestingly, in this instance, they relied on Article 31.3c of the Vienna Convention on the Law of Treaties. The Permanent Court of Arbitration followed a previous case, the Iron Rhine case, where essentially they used this interpretive device, if you like, from the Vienna Convention on the Law of Treaties to incorporate subsequently adopted obligations in respect of ecosystem protection into pre-existing agreements, to pre-existing watercourse agreements of immense significance, this idea of systemic interpretation or treaty evolution. Similarly, the San Juan River case, the relevance of Ramsar designation of a contested site was of key significance, and the statements are really, really supportive of and imply or infer the court's acceptance of an ecosystems approach, even with respect to territorial implications. They talked about the environmental inseparability of a wetland, which was part of a contested territory. Of key importance here also are non-water conventions. We don't simply have to rely upon the water conventions that we have. If we go back to the 1968 African Convention on Nature, Article 5 promotes the protection of ecosystems. Various regional treaties on marine protection of the marine environment from land-based pollution. Of immense importance, the 1971 Ramsar Wetlands Convention, and of course the Convention on Biological Diversity. Under these conventions, which are older than our water conventions, have had more opportunity for the elaboration of detailed rules and guidance. They provide a great deal of detailed normative guidance on what an ecosystems approach would involve, and are hugely important for us on understanding. We don't have a definition of an ecosystems approach. The Convention on Biological Diversity defines an ecosystem in terms of functional unit, having biotic and abiotic elements. Again, the 92 UNECE Helsinki Convention defines transboundary impact in a way that's very relevant to ecosystems protection. that transboundary impact includes human health and safety, flora, fauna, soil, air, water, climate, landscape, or the interaction between these elements. The 1994 International Law Commission commentary on Article 20 talked about an ecosystem as an ecological unit with living and non-living elements, and talked about the interdependence of these elements. The only real definition we have of any use is a 1994 definition by Brunet and Toup, writing in the Yearbook of International Environmental Law. They talk about the whole system, species and physical environment, the interconnectedness between these elements, that it's a spatially broad concept, and that integrity of ecosystem function is essential. So how do we implement it? Well, we mentioned EIA. EIA is essential for this kind of proactive anticipation of problems. EIA coupled with a precautionary approach. But we're increasingly receiving technical guidance, really, really useful technical guidance, through a process of communication occurring often under conventional instruments. For example, under the Helsinki Convention, we have 93 guidelines on the ecosystem approach in water management. Of central importance here is under the Ramsar Convention, the Scientific and Technical Review Panel, which has produced its handbooks on the wise use of wetlands, and various of these handbooks are very, very helpful in helping us to understand in detail what's required in terms of ecological protection of water bodies. And of course, national legislation is increasing in terms of its sophistication, in terms of its ability to address ecosystems problems in terms of water bodies and the water environment. A recent study by Stefano Burki that I went through identified around 8, maybe more, modes of national legislative implementation which would give effect to, or help to give effect to, an ecosystems approach. 2 key things I want to mention just before I finish in terms of the developing methodologies. And one is environmental flows. We're developing an understanding of what we mean by environmental flows through various types of guidance, soft law, the Brisbane Declaration 2007, guidance by the Scientific and Technical Review Panel of Ramsar, various guidance issued on Ramsar on the Convention of Biological Diversity, a number of other technical toolkits, the statements of the International Law Commission in relation to transboundary aquifers, and of course the case law, the 2013 Permanent Court of Arbitration, particularly the interim award in Kishiganga arbitration, and the final award, and the San Juan River case. So we're really getting a handle on what we mean by environmental or ecological flows, absolutely fundamental to ecosystems protection. And of course the idea of ecosystem services and the related requirement for payment for ecosystem services, again, provides us with an analytical framework for the economic and social valuation of ecosystem services, which really, really helps us to move towards understanding the significance of functioning ecosystems for the parties to a dispute, to an agreement, to a regime of international water law. The 2005 Millennium Ecosystem Assessment gave us a language, gave us a typology, 4 types of ecosystem services: supporting, provisioning, regulating, and cultural. And again, a wealth of technical guidance, all of which we've really seen since the adoption of the convention. So I think the ecosystems approach is really developing normative sophistication. We have a very, very clear idea on what this means. It's terrifically important that this was included, and included emphatically, in the UN Convention. It would be a huge gap. Our thinking on international water law would have moved beyond the convention if this provision were not included there. I think it's massively important that it was there, and I think it's indicative of the way that international law in this area, in terms of natural resources and environment, continues to develop organically. That this concept has developed while the convention itself was waiting to take effect. And it can now take effect when this one particular, this is true of other elements in the convention, but as this requirement has developed real meaning for us, real technical and practical meaning for us, the convention is ripe to enter into force now. When we, on issues like ecosystems protection, we know what the well-meaning requirements set down in 1987, what they actually mean. Thank you.
Thank you. That was an interesting and informative presentation that highlighted a part of the convention that I think a lot of people overlook often. So thank you for that insight.
Yes, terrific. Well, I'd just firstly like to thank Tom and Scott and the IWRA for organising this fantastic webinar, and to my esteemed colleagues for inviting me to be a part of it, and also to all the listeners out there for participating. So I'm really just going to, I guess, the 4 sections of my presentation are up there, as you can see. So my presentation is essentially pulling together what the 4 previous presenters have spoken about, and kind of looking forward now in terms of what are the practical steps that we can take for institutional coordination and coordinated implementation of these 2 what will essentially be global conventions, global water conventions, in force as of August, when the UN Watercourses Convention comes into force in August. So I'll be very brief. I'm just going to basically run through those key 4 points in my presentation. So I just want to set the scene, some key points to consider. Then I'll run through just a brief sketch of the complementarity and differences regarding both conventions and how they're a package of norms together. And then I really want to focus then for the majority of the presentation, and I won't be long, but I just wanted to focus on 3 basic options for institutional coordination and taking a package approach for implementing the 2 global water conventions. And then lastly, leading into discussion with all of the participants in the webinar, I kind of wanted to throw it out to where do we go from here, not only with the UN Watercourses Convention, but the UNECE Water Convention, and how will they work together, and then looking more broadly at MEAs and other institutions, and then throwing it out to obviously the wider audience for their consideration. So I'll just start. So here's just a few things to consider. So this, just to start the conversation, the presentation that I'm giving is essentially an amalgamation of a discussion paper that you can find on the internet, which Alistair, Flavia and myself wrote in 2012, 2013, when we were hoping that the UN Watercourses Convention would enter into force, but it wasn't actually a concrete reality as it will become. So, and that essentially looked at when it does come into force, how we, what are the options for coordinating both of those conventions. So there's a discussion paper there, and this is also an amalgamation of that with an article by Alistair and myself recently published, which is around what are the complementarities between the 2 conventions, and that leads into then how are they coordinated in a complementary way. So this is an amalgamation of those 2 pieces of work, which are otherwise available. And so I just want to set the scene here with some basic things to consider. So obviously, as of August 2014, there will be 2 legal framework instruments covering transboundary water issues in force effectively at the global level, with the UNECE Water Convention open to ratification from states outside of the UNECE, and with the UNWC in force as well. So this development raises the question of the compatibility of both instruments, and really the fundamental question that I'm considering is how they might be implemented in a coordinated manner. And in that, we have to look at the similarities and differences between them, but essentially what we've found in terms of the research that I've been a part of is that they're essentially complementary, and I think that comes out in most of the speakers today, and also in a lot of the research out there. Sorry about that. There's a significant benefit also in promoting and implementing the conventions as a package when it comes to implementing them in a coordinated way. And in terms of that, there are three basic institutional options that can be envisaged in terms of the research that I've been involved with to support that package approach. And so this presentation will discuss that package approach to implementation of both conventions and how that offers the best means by which to strengthen the law of international watercourses more generally. So I'll just go briefly into comparing the texts of both conventions. So the scopes of both conventions are largely similar. A key distinction here concerns their respective treatment of groundwater. I won't go into the details there, but that's up there on the screen. In terms of the substantive norms and the similarities and differences, they do offer a similar package of substantive norms. However, they are presented differently between both instruments. The UN Watercourses Convention places all substantive provisions under the overarching requirement of equitable and reasonable utilisation. In contrast, the UNECE Water Convention does not put equitable and reasonable utilisation at its forefront and generally takes the approach of the principle of do no harm or no significant harm. So, however, whilst they're articulated slightly differently, both conventions essentially adopt the same package of substantive norms that encompass the key principles of equitable and reasonable utilisation, prevention of significant harm, and the protection of ecosystems, which Owen just spoke about. Comparing the text of both conventions again in terms of procedural norms, there is a distinction between the UN Watercourses Convention and the UNECE Water Convention concerning the treatment of existing and future legal institutional arrangements. In the UNWC, states are encouraged to harmonise such agreements with the provisions of the Convention, whereas the UNECE Water Convention obliges states, where necessary, to revise existing arrangements in order to eliminate contradictions, but that they also must enter into watercourse arrangements where they do not already exist. While these distinctions may appear significant on paper, in practice they may be mitigated by the UN Watercourses Convention's consistent emphasis on cooperation at its heart. And then lastly, in terms of comparing the text, the dispute avoidance provisions, the two conventions provide relatively similar provisions regarding the settlement of disputes, by which both states are encouraged to seek a solution to any dispute. Are encouraged to seek a solution to any dispute by negotiation or other means, such as good offices, mediation or conciliation. One of the key differences is that UN Watercourses Convention explicitly provides for a fact-finding commission to collect any information relevant to a dispute. So there's some of the major substantive procedural norms in terms of their similarities and differences between the two conventions, as well as scope and dispute avoidance. So what does that lead us into in terms of coordination of these two? So here are some key questions for institutional coordination and implementation. So how best do we build on the synergies and ensure coordination and avoid duplication in the implementation of both of these conventions? How can states capitalise on both the global legitimacy of the UN Watercourses Convention as well as the vast experience under the UNECE Water Convention to provide a truly global transboundary water regime? How might an institutional framework address existing water law fragmentation at different scales, which I think Salman touched on, as well as Flavia as well? And then what steps would we need to take to ensure that these conventions receive the political, technical and financial support necessary to facilitate effective implementation? So here on your screens is just a diagrammatic representation of, and I have to preface this with saying that whilst I will present three basic main institutional options, this is by no means the only options, and these are just three options that in the course of my research with Alistair and Flavia as part of a bigger piece of work under the UN Watercourses Convention Global Initiative, we essentially sought to map out the potential institutional framework for implementation, covering not only the two conventions, but broader institutions, broader MEAs. And so what we've done here is we essentially distilled it into three basic main institutional options for the coordination of these two conventions, upon which to base a global regime for transboundary waters. So in option one, we have the UNWC institutional framework created and a UNECE Water Convention Secretariat mandated to also service the parties to the UNWC. So that's a combined. That's the combined option. In option two, we have the parallel option, where we have two formal institutional structures, but operating in a coordinated manner. And then in option three, we have the informal institutional framework or institutional arrangements that are currently in operation for the UN Watercourses Convention, which has no secretariat or the provisions within the convention to create such a secretariat, and the UNECE Water Convention operating as it does with a formal secretariat and formal bodies underneath the convention. So they're the three main options, but as I said, by no means at all the only options, and this is just some of the research that I've been a part of with some of my colleagues present today around trying to flesh out what the future institutional framework may look like for implementing these two conventions in a coordinated manner. So I'll just delve into them one by one briefly in terms of their strengths, basic opportunities, and some of the weaknesses and threats under each of them. So in the first one, which is, as we saw, was a combined option with a combined secretariat operating for both conventions. I won't go into detail, but I mean, this is available, as I said, online, and I'll provide the details after we're done. But you can see there, so the strengths of the combined option is it's likely to be the most effective means by which to ensure that both instruments develop in a complementary and mutually reinforcing manner. A shared secretariat would also offer the most effective and efficient means by which to develop a common strategy for promoting new membership to both conventions. This option would also create a clear entry point and one-stop shop, which I think Flavia touched on in terms of having that kind of focal point and beacon for championing transboundary water issues at a global level. And also it would require less resources and time compared to establishing a completely new secretariat and separate activities for the UN Watercourses Convention. Some of the weaknesses and threats of this combined option are that one that we thought might be possibly an issue is the fact that a secretariat based in Geneva may be perceived as being less favourable by some countries, given that the UN Watercourses Convention is a global convention, and there may be riparian nations who would prefer a new secretariat to be set up in somewhere else. But as I said, this is just kind of throwing ideas out there as to possible weaknesses and threats. This may or may not be one. And also, this option will require both a formal decision among the parties to the UNECE Water Convention to expand the mandate of their secretariat, and would also require an amendment to the UN Watercourses Convention incorporating provisions on governance mechanisms, and that could take considerable time and resources to secure. So option two was the parallel option, where you have both conventions with formal institutional arrangements, but operating in a coordinated manner. So the strengths of this basic option is that if it was hosted by an existing global organisation active in water issues, the UNWC could provide that organisation with a strong legal mandate to further its aims and objectives. It would also be an opportunity to create an entirely new governance mechanisms for the 21st century under the UNWC. As opposed to the option one, it would not require any further changes to the UNECE Water Convention institutional framework as it currently exists. The UNWC Secretariat could be located in a developing country and or in a region where there is a strong need to enhance transboundary water arrangements. And this could give added impetus to strengthening transboundary water cooperation in that country or region as a possibility. There's also the fact that non-UNECE states could be more attracted to the UNWC with its institutional home being a global body rather than a structure associated with the UNECE as it currently stands, which was essentially set up as a regional convention, obviously with global aspirations. The weaknesses and threats of this parallel option with two formal arrangements operating side by side is that a formal secretariat and many of the parties would require all parties to agree on the adoption of an amendment, which could take time. If hosted under an existing organisation, this would require a decision by the governing body of that organisation in question, which again could take time and resources to secure that positive decision. And where the governing body of a potential host is made up of states, considerable effort would likely be required to build widespread or otherwise required unanimous support for that decision. Some other weaknesses and threats of this parallel option is that creating two parallel regimes would require high startup costs and running costs for two institutional frameworks. Separate secretariats would increase the effort, time and resources required to coordinate between both of those institutional frameworks under both conventions. It might be easier to demonstrate the benefits of two institutional frameworks serviced by a unified secretariat as envisaged in option 1, given that the UNECE Water Convention regime is already established. And similarly, a less formal arrangement as described in the next option might prove more feasible than in this parallel arrangement. And so we'll go into option 3. And so option 3 is essentially what is happening at the moment, where you have the UNECE Water Convention with a formal structure under the UNECE Water Convention, and you have the UN Watercourses Convention operating without any formal institutional structure or the provisions within the convention for those formal mechanisms, but at the same time garnering support through informal mechanisms and the championing of certain riparian states, and that is essentially what is happening at the moment. So the strengths of continuing in this kind of current situation would be that there would be the fact that there's no formal institutional framework established coincides with the current situation, which might be more acceptable to the parties that originally ratified the UN Watercourses Convention on the basis that there would be no need for financial commitments to support such a mechanism. The informal arrangements could be put in place to support the implementation on development of the UN Watercourses Convention in the absence of a formal institutional framework, so that it could continue as it currently is, which may be a more attractive option for parties. The cost of this option would be relatively low and non-structural, and this option would also accommodate proposals that have already materialised to host a meeting of the parties upon its entry into force. And some more strengths associated with this option are that an informal platform could evolve into a more sophisticated mechanism down the track, so this doesn't actually preclude a formal institutional arrangement evolving from the informal arrangements at present, as has happened with other MEAs. The UNWC would remain an authoritative statement of existing and emerging customary international law, and obviously now entry into force in force treaty as well. And the again, focusing on the fact that there could be an evolution of the arrangements from informal to formal, which would essentially move them into either option 1 or option 2 as the parties saw fit. Weaknesses and threats under this option 3 of the status quo is that the absence of an institutional home for the UN Watercourses Convention may be seen as a barrier to accelerating further ratifications in the future, in terms of having that champion to push that agenda. The lack of a mandated structure to oversee the UN Watercourses Convention may make it harder to mobilise donors and partners around implementation, and it also may be and this is a crucial point, harder to coordinate activities between the UNECE Water Convention and the UN Watercourses Convention if there's no formal institutional framework for the latter instrument. So, some key points to consider for all the options as I wrap this up is to allow the UN Watercourse, so effective coordination would allow the UN Watercourse Convention parties to capitalise on 20 years of experience in the implementation of the UNECE Water Convention, which has a very storied and extensive history of highly technical experience in implementing the convention and also developing sub-bodies under the agreement for implementing the convention. Also, this would provide parties to the UNECE Water Convention with the opportunity to exchange experience with parties to the UN Watercourses Convention. It would also enable both conventions to operate at the global level whilst providing states with some flexibility. And what you're seeing here is that all three options essentially envisage either or both conventions operating at the truly global level, and what we're going to see in August is both conventions operating essentially at a global level. What I'll do is I'll just wrap this up with the final key points to consider for future coordination and implementation. These are the 3 points that I'd kind of like to throw to the wider audience and to kind of get that conversation started, is that there are key similarities and differences between both conventions, but collectively, when taken together as a package of norms, both conventions are generally complementary in nature in the texts and provisions of both conventions. There are many ways in which both conventions may evolve in terms of formal or informal institutional frameworks, whether that be separately or together. But whilst there are many ways that could happen, there are several basic options which exist which may assist in the planning for their future coordination. And having said that, the final point being whichever method is considered for their separate or joint coordination, and whatever way the development of both conventions continues, the experience from other MEAs shows us that coordinating these 2 conventions will enhance their mutually effective implementation. And to seize on what Flavia said, and I think what all of my colleagues and many people out there will probably agree, is that this is a unique window opening now to seize the opportunity for planning this coordination. So I'd like to thank everybody for listening and pass it over to you, Scott.
Thank you very much for that presentation. The first question we have here is, a couple people have asked some questions regarding enforcement and non-compliance. So the question would be, what are the consequences to non-compliance with the Watercourses Convention? Can you please discuss the enforcement mechanisms? And then how can we apply the lessons learned from the UNWC to other, future practices in the state and international level regarding enforcement? Anyone can respond to that.
Well, shall I have a go, and then feel free to others to chip in. My point would be that if you start thinking about enforcement and a very centralized top-down enforcement mechanism to ensure that the convention is implemented, then you'll fail. It's not how the experience, particularly from multilateral environmental agreements, it's shown very well in the UNECE Water Convention, is that what is required are mechanisms to promote compliance, to ensure that there are the technical, financial measures underneath a treaty regime that can support areas capacity building to strengthen implementation of a convention, or it could be more general mechanisms at a cross-cutting mechanisms within a treaty regime, such as an implementation committee. Compliance committee is one just established under the UNECE Water Convention to identify, have a reporting mechanism to identify what's happening in terms of implementing the convention, maybe some difficulties and bottlenecks, and then think about some strategies and solutions to support that compliance, to the implementation. And I think that the track record now we have quite a lot of experience actually of implementing MEAs. We can say that's a much better strategy, and I think if we talk about enforcement, then we're really missing that important picture.
Okay, thank you very much, panelists. I've muted your microphones. We're having a lot of background noise, so if you would like to respond, please just raise your hand real quick, and I will unmute you, and that'll keep our background noise down to a minimum. Okay, I'll go ahead and Dr. Salman, did you have thoughts?
Yes, I just want to briefly add, to agree with and endorse what Ali said, but I want to add one quick statement. That this is the UN Watercourses Convention is really a framework convention, which is to be complemented by watercourse specific agreements that would take into account and into consideration the specific circumstances surrounding that watercourse. So I think we have to keep that in mind also when we talk about compliance. This is really a framework convention. Thank you.
1 second, Professor McIntyre. All right, Professor McIntyre.
I would just say very briefly, agreeing both with Ali and Salman, that in many ways to focus on compliance or to focus on a compliance mechanism is to misunderstand the function of an instrument of this sort. That this instrument is really about assisting states in developing further arrangements, if you like, as between them, where states are interdependent because they share, critical water resources. This provides a starting point for negotiation for the onward development and elaboration of rules that are appropriate as between those states, which might, in fact, if those states trust each other enough, or don't trust each other enough, might result in certain types of compliance mechanisms. But it's to misunderstand a global instrument of this sort, and indeed many of the key instruments in international law are much more around facilitating effective communication between states than having a hard and fast and binding set of rules which can be enforced as such in the way that domestic laws are.
Excellent. Well, I think that's a good summary of the answers. And we go on to that was a question from Flavia had sent that in before the presentation began. So I'm not sure who that originated, but you're passing it along. And thank you very much for that. The next question comes from Benjamin Nori, and I'm going to combine that with a question from Kui, who basically are looking a little bit more specific answers. How will the entry into force for the UNWC, how will that affect some specific basins and areas of the world? We're talking about the Mekong or the Nile, or how could this perhaps be more broadly applied to the entire Asian region? Who would like to start us off? Any takers? Oh, Professor McIntyre. All right, thank you. There you go.
I think the reason you have hesitation on the part of the speakers is there are maybe 30 answers to that. We can answer that in any number of ways. One way that I think occurs to me, and that maybe I had meant to mention in my presentation distance, was that the UN Convention is largely a codification of customary rules. But the fact that these rules are included in the Convention, and the fact that the Convention then enters into force, greatly enhances their status as custom. And so these rules really are, whether states become party to the UN Convention or not, or Watercourses Convention or not, are greatly enhanced in terms of their generally applicable customary status. So in terms of all of the various provisions that are in the convention, I think they are greatly enhanced by its entry into force. I think we have to be quite clear about that. It's very, very important that it enters into force, and its entry into force will probably give rise to ratification by more states, which will again further enhance the customary value of the key provisions, and we have a virtuous circle in terms of a clarifying of any of the grey areas that are left in international water law. Specifically, thinking about, say, the Asia region, I would say that dispute settlement might be a very interesting development in that particular region, where states are very, very, very slow to go to dispute settlement. Or to even recognise that there is a dispute, an interstate dispute. And the fact that you have quite an innovative, quite non-threatening in many ways mechanism within the convention. The only compulsory element of dispute settling is non-judgmental fact-finding, just basically to try and establish the facts with an independent commission. That perhaps that might encourage states in the Asia region, the broader Asia region, to engage more in formal dispute settlement along a fact-finding route. I would hypothesize, or I would anticipate, that might be one particular benefit that would have for that region. I'm sure my colleagues can think of many more.
Yeah. Who else would like a crack at that? All right, Remy, I'll unmute you here. All right, Remy.
Thanks, Scott. Yeah, I just support what Owen said in terms of the, looking at these as framework, the Watercourses Convention as a framework convention. If you look at the two essentially regional transboundary water sharing agreements, both in the UNECE, which is obviously now becoming a global agreement, essentially, effectively, in terms of it's open to ratification by states outside the UNECE, but also the Southern African Development Community shared revised protocol on shared watercourses. I think Salman wrote a very good article back in the day around the looking at the complementarity or the key similarities and differences between the UN Watercourses Convention and the SADC revised protocol. And looking at those two instruments, there are differences between the two, but it's kind of a similar situation to the UNECE Water Convention, where the basic provisions are there and to support the complementarity, and the regional and even all the way down to basin level agreements essentially provide the context for those basins and those regions, and the UN Watercourses Convention provides that global baseline upon which to elaborate for those contexts. And the focus of the Southern African Development Community on regional development and economic integration, and the UNECE Water Convention's focus on transboundary harm and pollution prevention. Those are the kind of functions of those, or the contextual niches of those specific regional agreements, and that builds on the kind of global baseline of the Watercourses Convention.
Okay, excellent. Thank you. Thank you very much. Dr. Salman, the floor is yours.
Okay, I would like to address the issue with regards to the Nile countries and their response to the UN Watercourses Convention. And I just would like to bring that to the attention of the panelists as well as the audience, that I wrote a blog on, which was published in Gabriel Eckstein's website, International Water Law Project, as well as in my website. And the title of the blog was Entry into Force of the UN Watercourses Convention. Where are the Nile Basin countries? With a question mark at the end. And I thought the question was important, because going back to the 1997, when the convention was adopted by the General Assembly, there were really 4 very divergent positions of the Nile countries. Sudan and Kenya voted for the convention. Burundi voted against the convention. Egypt, Ethiopia, Tanzania, and Rwanda abstained, but abstained for different reasons. And then Uganda, Democratic Republic of Congo, and Eritrea did not attend the session. So you have the 10 countries, each, there are 4 groups of where those 4 countries stood. And I'd like to spend a minute why Egypt, Ethiopia, Tanzania, Rwanda abstained, and the different reasons. Egypt abstained because, and they recorded saying that they felt the convention is much more on the side of the equitable and reasonable utilization. It has not given enough attention and enough weight to the question of no harm and the existing uses, which is a basic principle that Egypt relies on. On the other hand, Ethiopia, Tanzania recorded their one concern with the objection is that the notification, which came out later on. They felt that the notification procedures they were concerned that it could be construed as giving recognition to the 2 colonial treaties, the 1902 and the 1929 treaties, which give Egypt a veto power over their projects and programs. Rwanda felt the same way, although they did not record this. So we have different reasons for abstention. And this same problem, the same positions, voting against the convention, and abstaining were later taken on when the Nile countries started negotiating the cooperative framework agreement. The same problems that were surfaced and prevented those countries from joining the convention came on the CFA. But they took different positions. They took different positions in CFA. Egypt and Sudan opposed the CFA. The upper riparians adopted the CFA and signed it. Ethiopia now has ratified it, but without the notification arrangements of the convention. The notification procedures that were laid down in details in the convention are not there in the CFA. There is just an issue of exchange of data and information through the commission that would be established. So the main problems that surfaced in 1997 and late 1998 about the convention really surfaced later on the CFA. They were not resolved fully, and the same problems are still prevalent. So the issue for the Nile Basin countries is really to resolve the issue, or to resolve their differences over the colonial treaties. Without resolution of their positions on the colonial treaties, there will be problems with the convention, there will be problems with CFA, and there will be problems with the Ethiopian Renaissance Dam and the others and the other projects that are to be built in the upper riparian countries. So this mainly the dispute on the colonial treaties is still prevalent, and it will continue and will stand on the way not only on those treaties but also on future cooperation between the countries. Thank you.
Thank you, Dr. Salman. It was a good technical discussion, I know, of an area that a lot of people are very interested in hearing about. I think I'm going to go on to the next question here, and this will kind of serve to orientate us moving forward a little bit. Coming from Heidi Jinkel at the German Federal Ministry for the Environment, Nature, and Conservation, asks, how do stakeholders and leaders think we can promote things going forward? How can we promote the convention? How can individual states be active in addition to obviously ratifying, but what else can be done to promote the convention and I guess both the customary international law and the goals that it enshrines? Anyone want to? Flavia? There you go. Thank you. You have the floor.
Yeah, and thank you, Scott, and thanks, Heidi, for the question. She's someone that we've been working with also over the years, so I'm glad to hear that she's joined. In the report that Ali and Remy, to which they referred before, that was one of the issues that we looked at. What is the architecture, and who's out there basically working on transboundary water issues, and what role they could eventually play. And it's easier to look at specific actors because they would each have different roles to play. And just for some examples, I mentioned briefly the Global Environment Facility. The same way that the Watercourses Convention doesn't have governance mechanisms, it doesn't have a funding mechanism explicitly included. And funding, it's what it all boils down to, right? If you don't have funds to do things, then things really can't move forward. So going back to the recent example of the Mercury Convention, that it was included in the text, but immediately upon, as ratification started happening, the parties went back to the JEF and confirmed that we want the Global Environment Facility to become our funding mechanism. So, and that's what the JEF has been doing, funding all these different MEAs. So the first thing was for the JEF to include in their new strategy for this new cycle explicit references to these two conventions so that they acknowledge that this is coming up. But now what needs to happen is for the parties to come together and request JEF to become this this funding mechanism, since that's not there included in the convention. Another set of actors that I would refer to is, again, river basin organizations. During the ratification process, we worked very closely with many of them, and they really have this convening power, facilitating power to bring their member states together and create a forum in which they can discuss pros and cons, any fears, any concerns that they may have. So river basin organizations should step up and embrace this role. And I'm hoping that this forum that UNEP will organize in November will, as an outcome, will have very concrete proposals of how RBOs can do that. Again, funding would be needed for this, so it goes back to the GF issue. And again, in terms of starting from now, none of these actors would have to start from scratch. The UN Watercourses Convention Global Initiative leaves an incredible legacy behind, and again, I have to thank all the other speakers here because they've all contributed to this legacy, and that our online users guide is all there, so they can look at specific basins and think what the research that we've covered on specific role that the convention could play, so they don't have to start from zero, like we did when we were starting the global initiative years ago. So, and I think the message is different actors will have a different role to play, but they all have a very good, very strong baseline from which to start, and that's on the online users guide. So hopefully that will support anything that they decide to do on this. Thanks.
Dr. McIntyre, did I see your hand there, or did you have a point to make?
No, my screen went blank. I was just trying to bring back my screen.
Oh, sorry. Okay, then Dr. Salman, did you have a point?
No, Ali is raising his hand.
Ali, okay. Ali, I'm on both sides of you here. There we go. Gotcha. Professor Rieu-Clarke?
Okay, I think that's working now.
Yeah, there we go.
Great. I just wanted to add to what Flavia has already said, and good to hear. It's a nice question from Heidi. We have a lot of experience in workshops, running workshops, training and awareness raising workshops around the international water law generally and Watercourses Convention, West Africa, East Africa, Southeast Asia, nationally in Vietnam, Cambodia, Ethiopia, Tanzania, and more recently in Palestine. And there's such a tremendous value in just sort of raising awareness. I mean, essentially, the Watercourses Convention, the UNECE Water Convention, at their core is a simple message, and it's about cooperation. States must cooperate over these resources. The international watercourses they're indivisible. They require cooperation. So where some states may try to refrain from such cooperation, ultimately to ensure their fair and sustainable use, there must be cooperative arrangements in place, and that's the essence of both these framework conventions, at least at a global level, trying to push for that. And so trying to get to the heart of what that means within the conventions and address some of the misunderstandings and misperceptions. Salman has mentioned about this, whether notification really provides a right to veto, and I say it certainly doesn't. He produced a fantastic piece in Water International addressing these misperceptions, misrepresentations, and I think a lot of work can be done within workshops, within the materials. Flavia mentioned the user's guide to just simply get that message out there. That there's at the core of these instruments is this duty to cooperate, and we must do our best to promote it. And certainly entry into force of a Watercourse Convention provides a nice milestone. There's a lot more work that needs to be done, but a nice milestone and perhaps as we mentioned before, a snowball effect to promote this message.
Can I make one very brief point? Heidi's question, I think, related to what can individual states do. And I would suggest that one thing that they can actually do is where they do provide overseas development assistance, to actually look at where states have a problem with water, where there is a problem in terms of cooperating with water, and to try and promote the convention among states that that donor states deal with their partners in developing states, and seek to promote the convention in that way. I mean, one of the drivers for a number of states to ratify the convention was basically so that they could be in a position to promote the convention in their overseas development assistance. So that's perhaps just one, as a very brief input, one way that individual states perhaps can bring some influence to bear, be persuasive. Thank you.
All right. Well, thank you. Does anyone else have a point on that? No? Okay. Well, I see that we're about 20 minutes over our allotted time, so I'm going to go ahead and wrap that up. We have a few more questions remaining, and I'm going to forward your questions to our panelists and ask them to respond to you all offline. But I think we were able to get to answering, if not your specific question, then at least the thoughts behind your question for many people who had asked and written to us. I'd like to thank again our panel for your participation today. Thank you for giving us your time, giving us 20 extra minutes of your time. So thank you to Dr. Alistair Rieu-Clarke, Dr. Salman, Dr. Owen McIntyre, Ms. Flavia Loures, and Mr. Remy Kinna. Thank you very much for your time. And I think today we did really discuss a lot of great points about the UN Watercourses Convention. The instrument has been under development for such a long period of time. With Vietnam signing, it raised a lot of excitement. I saw a tremendous outburst of energy, but I think it also raised a lot of questions about where was the instrument going, where is international water law going in the future. And I think that this webinar answered a lot of those questions. I think it raised a lot of other interesting questions to talk about in the future. I'd like to remind all of our listeners that this webinar is based on the special issue that was edited by Professor Alistair Rieu-Clarke, Mrs. Flavia Loures, and Mr. Remy Kinna from Water International, the IWRA's flagship journal. And it is also the subject of our forthcoming policy briefing, which will be available on our website, www.iwra.org, very soon. So you can go to our website and you can enjoy the policy briefing. It's a short explanation and summary of the topics covered here in the webinar. So I would like to thank everyone for tuning in today. On behalf of the whole IWRA staff, I'd like to remind everyone that we are a nonprofit. We are a non-governmental educational organization. We work on bridging disciplines and geographies, connecting professionals, connecting students, individuals and corporations and institutions, everyone who's concerned with our sustainable water future. We are hosting a World Water Congress next May in Scotland, in Dundee. We'll be having University of Dundee will have a strong water law track there. Will be helping us. So if you are interested in these topics and these issues, please consider coming to Scotland with us. And if you're interested in learning more about our organization, more about the work we do, please go to our website, www.iwra.org, and you'll learn more, and you could potentially become a member. So please consider going to our website and learning more. Thank you for tuning in today. Thank you for viewing. Thank you for your time. Have a good day or night, as it is wherever you are. Thank you for your time. Just we can all log off.